The defense attorney was already on his feet when I came back onto the bench, motion in hand, voice sharpened and ready, as if he had been waiting for me to breathe before he struck. Before the court rules, he said, the defense moves to preclude any use of the warehouse manifests and all derivative testimony connected to them. I did not touch the paper at first. I looked at him, then I looked at the defendant. He was seated at counsel table in a dark suit that cost more than some people's monthly rent, one hand flat on the wood, the other turning a ring, one slow notch at a time. He did not look surprised. He looked early. That was the moment the room changed for me, because I had not ruled on the warehouse manifests, not in open court, not in chambers on the record, not in writing. The only words I had spoken on that issue had been the night before behind my door, to two people, my clerk, my bailiff, and the ruling I had spoken was false. The defense attorney kept going. He always kept going when he thought momentum belonged to him. He cited prejudice. He cited chain of custody. He cited inflammatory impact. He laid out, in perfect order, the exact argument one would make only if one knew what I was supposedly about to do with that evidence. 5 times in a row, the defense had anticipated my private pre-trial decisions. 5 times. This was the 6th morning, and this time I had baited the hook myself. He slid the motion toward the clerk's station. I still did not touch it. The courtroom was full that morning. Organized crime trials have gravity. They pull in reporters, spectators, off-duty lawyers, retired officers, people who smell power and want to sit close enough to feel the heat. Nobody in that room knew what I knew in that moment. To them, it was another aggressive motion from a high-priced defense team. To me, it was a witness taking the stand against the walls of my own courtroom. The attorney cleared his throat. "Your Honor?" I leaned forward. "Counsel," I said, "you seem unusually prepared for a ruling I haven't made." A ripple moved through the gallery, tiny, quick, the sort of movement people make when they know enough to be nervous and not enough to leave. The attorney smiled the way weak men smile when money is standing behind them. "Preparedness is not misconduct, Your Honor." "No," I said, "but timing has a voice." He tried to answer. I did not let him. "Sit down." He did not sit. That was the first fight. Not fists, nothing so honest. Just a lawyer trying to stay on his feet half a second longer than the bench had permitted, so the room would see defiance where there should have been obedience. "Sit," I said again. This time he sat. I took the motion, looked at the caption, the citations, the relief requested. He had even attached a proposed order. They always become bold when they think the map has already been stolen. The defendant glanced once toward the side door where my bailiff stood. One glance. That was all. But in a courtroom, one glance can be louder than testimony. I placed the motion down very carefully. "Motion is received," I said. "Argument deferred. We will proceed." The defense attorney rose again at once. "Your Honor, with respect, the defense requests immediate consideration before any taint." "Counsel," I said, "you're beginning to mistake my restraint for permission." He sat back down, and I began the day. If you have ever believed that corruption announces itself with sirens, let me tell you something I learned too late. Sometimes it wears a clean uniform, opens doors for jurors, and says, "Good morning, Judge." The trial itself was already a war by then. Weeks of testimony, financial records, shipping logs, witnesses who suddenly forgot what they had once told investigators, men who entered through the front doors with subpoenas and left through side exits under escort because they thought somebody might be waiting by their cars. I had presided over difficult matters before. I had seen intimidation dressed up as procedure, delay disguised as principle, and arrogance wrapped in constitutional language. But this was different. This felt like my courtroom was speaking in 2 voices. The first time I noticed it, I told myself not to be dramatic. Judges who chase every shadow stop seeing the law clearly. I had discussed, in chambers, a narrow ruling on a cooperating witness. It was not final, just a preliminary direction on what I was inclined to allow if foundation was laid the next day. The discussion was private. Nothing had been filed. The next morning, before the prosecutor reached the lectern, the defense produced a motion attacking the very foundation I had expected to see. Sharp motion, clean motion, landed exactly where my private concern had been. I remember holding it in my hand and thinking, that is too neat. Then I did what judges must do when suspicion has not yet earned its name. I ignored the feeling and ruled on the law. The second time, it happened with an exhibit index. A bundle of transport records the state intended to use to tie a shell company to a warehouse. I had told my clerk I wanted tighter authentication before I would admit them. Nothing more. The next morning the defense arrived with an affidavit package and a prepared challenge to the custodian of records before the custodian had even been called. Too neat again. Still, coincidence can wear a convincing face. I have seen lawyers guess right. I have seen good lawyers smell where a court is leaning. Experience teaches them patterns, tone, timing. One raised eyebrow can become tomorrow's motion. So I said nothing. The third time, I stopped telling myself stories. It was late. The courthouse had emptied. My clerk and I were reviewing a sealed proffer tied to a witness relocation issue. I remember the lamp on my desk and the sound of the air system knocking softly in the vent. My bailiff was by the door. He had that still posture some officers learn after years of standing where they are told to stand. We discussed whether certain identifying details would be redacted before morning. The next day, before court began, the defense filed an emergency motion objecting to any attempt by the state to sanitize identifying material in a manner that impairs confrontation. Word for word, they attacked a decision I had not yet placed on the record. That morning, I did not look at the attorney first. I looked at the people nearest me, my clerk, who had served in my chambers 11 years, my bailiff, appointed 6 months earlier. The clerk kept her eyes on the calendar, calm, efficient. The same woman who had worked beside me through murders, political scandals, and cases that put reporters in the hallway from dawn until lunch. She had earned trust the hard way by never asking for it. The bailiff opened the side gate for counsel and nodded to jurors as they filed in. If there was a crack in the walls, it was not visible then. So I did what a judge does when the truth refuses to come in through the front door. I began to build a record in my own mind. Fourth time I changed my habits. No emails, no draft orders left on printers, no unnecessary discussion in hallways. I shortened every pre-trial conference. I used fewer words. When you suspect a leak, language becomes currency. You spend as little as possible. Did it matter? No. The defense still arrived, prepared for a ruling I had not made. Not prepared in the general sense. Not good lawyer prepared. Not, we anticipated the issue, prepared. Prepared the way a man is prepared when somebody has already read him the exam. By then the defendant was getting bolder in ways that would have escaped a careless eye. He stopped leaning in to hear his lawyer. He leaned back. He watched the room. Sometimes he would look at me as if he were measuring whether I had caught the scent, and if I had, whether I had the nerve to follow it. One morning, after a particularly hard-fought evidentiary argument, I rose from the bench and stepped through the side door. My bailiff was there before me, as always. "Long day, Judge," he said. I nodded. His phone vibrated in his pocket. He silenced it without looking at the screen. Nothing illegal in that. Nothing even unusual. Human beings receive messages. Courthouse staff live on their phones more than they should. I know that. But I know rhythm too. And something in the rhythm of that trial had turned rotten. If you were in my seat, what would you have done? Point at the nearest person and accuse them on instinct. Tear apart a courtroom on a hunch. That is how reckless men operate. The law does not allow me that luxury. The bench is not a place for panic. It is a place for proof. So I waited. And the fifth time came. The prosecution intended to call a financial analyst to summarize deposit patterns across several accounts connected to the defendant's logistics network. Technical testimony, dry on its face. But dry evidence is often the evidence that buries powerful people because numbers do not get frightened in parking lots. The night before, I told my clerk I was inclined to permit a summary chart subject to a limiting instruction. I said it in chambers, quietly. No one else in the room but my clerk and the bailiff. The next morning, the defense filed a meticulously drafted objection to composite financial charts lacking independent evidentiary status, with every relevant case already highlighted. I remember the sound the papers made when they landed. That flat, clean slap on polished wood. I remember looking up at the defense attorney and seeing not confidence but comfort. And that was worse. Confidence means a man believes he can win. Comfort means a man knows something you do not want him to know. I adjourned early that day, not because I had enough, because I had just enough to become dangerous if I moved badly. After the courtroom emptied, I remained seated for a long time, not thinking in circles. Judges cannot afford circles. I was subtracting people. Court reporter? No. These issues were raised before anything went on the record. Counsel, impossible. The leak preceded courtroom argument. Clerk, 11 years at my side, clean history, consistent, no unexplained shifts. And more than that, I had watched trust under pressure before. Trust does not come from sentiment in my line of work. It comes from repetition. Years of doors closed, files handled, storms weathered. That left the man who had entered my courtroom only 6 months earlier with a city council recommendation folded neatly into his personnel packet. Appointed, I was told, because he was steady. In criminal court, I have learned to fear that word when it arrives too polished. The next move had to be precise. A trap does not work if your own anger steps on it first. So the following evening, after we had recessed and the last attorney had gone home, I called my clerk back into chambers. The bailiff was by the door. I took a file from the stack and set it in front of me. Then I said in an ordinary voice that I had decided to exclude the warehouse manifests entirely the next morning unless the state could establish a different custodial chain than the one already proffered. That was the bait. A false ruling, clean, specific, valuable enough to trigger a leak, limited enough to identify the source. My clerk made a note. My bailiff said nothing. I closed the file. We went home. I slept very little. People imagine judges sleep well because the robe looks heavy and final. Let me correct that fantasy. Sometimes, you lie in bed staring into darkness, replaying words you chose on purpose, wondering whether the poison is really in the room or only in your mind. Morning came anyway, and with it came that motion, the one the defense attorney was so eager to argue before I had even taken my seat. He was ready to block the warehouse manifests before the issue had breathed in open court. That was confirmation, not suspicion, not instinct, confirmation. Only 2 people had heard the false ruling, and one of them had stood beside me for 11 years. I did not reveal any of that in the moment. A courtroom is not the place to satisfy personal outrage. That is another mistake amateurs make. They confuse exposure with control. Once you show your hand, every rat in the building starts running. So I held the line. We proceeded with witnesses. We argued objections. We broke for lunch. The defense attorney kept trying to force the warehouse issue, kept standing, kept pressing. He wanted it heard immediately because he thought the leak gave him a half-step advantage and he intended to spend it before the source went cold. I denied him the timing. 3 times he pushed. 3 times I shut the door. By the afternoon session, even the jurors could feel that something in the room had gone rigid. When we recessed, I did not speak to either my clerk or my bailiff about the motion. I went into chambers, closed the door, picked up the phone, and called the court marshal's office. I requested a routine security review. Not an investigation, not yet. Routine. That word matters. Routine does not spook the guilty until the door is already locked. The chief marshal came himself. Old school, minimal expression. The kind of man who understood before I finished the sentence that this was no paperwork exercise. I gave him what I had. 5 anticipations, 1 trap, 1 result. He did not waste my time with speeches. Who knew, he asked. My clerk and my bailiff. He wrote both names down. Then he looked at me and said, "If you're wrong, you damage your own house." "I know," I said. "And if you're right, then my house has already been damaged." That review began quietly. Personnel files first. Access logs. Camera angles in hallways. Nothing theatrical, no badges snatched, no whispered swarms of deputies. Just professional hands lifting floorboards 1 plank at a time. The first resistance came fast. Human resources delayed the bailiff's full appointment paperwork. Misfiled, they said, then archived, then pending transfer from another division. 3 explanations in 1 afternoon. Whenever records start moving like that, it means somebody in the bureaucracy has decided confusion is safer than clarity. The chief marshal sent back a 1-line message. Push harder, so he did. By evening, the file was on my desk. There it was. City council recommendation, fast-tracked appointment. And 1 item that had never crossed my chambers before because it sat buried in employment materials no judge ordinarily sees unless something goes wrong. Emergency contact information and immediate family employment disclosures. The bailiff's brother worked for the defendant's logistics company, not owned by the defendant on paper. Men like that are rarely foolish enough to put their names on the thing that carries the money. But it was his network, his company in every way that mattered except a letterhead. I stared at that page for a long time, then I closed it. Because family relation is smoke, not fire. A brother's job is not a crime. It is an alarm bell, yes, but judges do not jail people because bells ring. We wait to see where the flames are. The next morning, before court, the defense attorney came in louder than usual. He wanted another hearing, immediate reconsideration. He was overplaying the strength he thought he had. That is what people do when hidden advantages begin to make them feel invincible. I let him talk for exactly 20 seconds. Then I said, "Counsel, you will stop trying to choreograph this courtroom." He froze. The defendant did not. He tilted his head and looked toward the side of the room again, toward the bailiff. Not long, not enough for anyone in the gallery to gasp and point, just long enough for me to see it. "If you're still with me, stay with me now, because this is where the clean shoes start leaving mud." The Marshal's office expanded the review. Financials required process, paperwork, lawful access, patience. We proceeded carefully, quietly. You do not poke a hole in a network like that unless you are ready for everything that may come pouring through it. Meanwhile, the trial kept moving. That is the part people never understand when they watch these things from the outside. The machinery of justice does not stop because the building itself may be bleeding. Witnesses still testify. Jurors still listen. Lawyers still object. The flag still stands. The seal is still over my bench, and I still have to rule as though the floor beneath me is not shifting an inch at a time. A week later, the Chief Marshal returned. He did not sit down. He placed a sealed summary on my desk and said, "We have deposit activity." I opened it. $40,000 in new cash deposits over 3 months. Not salary, not overtime. Not explained in any way that matched the employment file sitting in my chambers. Spread across deposits carefully enough to look casual, clumsily enough to look criminal, once somebody had finally bothered to line them up. I remember asking, "Has he been interviewed?" Preliminarily. And? The Chief Marshal flipped one page. First explanation was family loans. Second was sale of a motorcycle. Third was old cash kept at home. 3 stories. Honest men forget details. They do not reinvent the source of $40,000. But still I wanted the nail, not just a hammer raised over it. So the Marshal asked for authority to conduct a device review under courthouse security protocols tied to staff communications on active organized crime proceedings. Lawful, narrow, necessary, approved. The next collision came in a plain room with bad lighting and no audience. I was not inside for the initial contact. I learned the sequence from the Marshal's immediate report and then from testimony that followed after the arrest, and every word of it stayed within what was seen, heard, and documented. The bailiff was asked for his phone. He said it was personal. He was told that in the context of the review, devices used during courthouse duty hours were subject to examination. He said the battery had died. He put his hand into his pocket, not to hand it over, to hold it there. The Marshal told him to remove his hand slowly. Instead, he turned half a step toward the hallway. That was enough. The phone was secured. And with it, the lie ran out of corridor. Extraction took less time than the damage it revealed. 47 text messages to a number registered to the defense attorney's paralegal. 47. Not one reckless message. Not one late-night lapse. 47 separate acts. Some were timing updates. Some were alerts on scheduling. Some were references to judge leaning on issues that had never yet reached the public floor of the courtroom. One message, plain as a confession and stupid as greed, referenced warehouse docks probably out tomorrow unless state fixes chain. That was my false ruling, carried out of my chambers in somebody else's pocket. When the Chief Marshal brought me that printout, I did not say a word for several seconds. The silence in a judge's chambers can become its own verdict. Then I asked, "Where is he now?" "In custody." "Good," I said. Not loud, not dramatic, just good, because the law had finally put its hand on something solid. The arrest happened before the defense attorney understood the bridge had collapsed beneath him. He came into court that afternoon full of outrage and false surprise, demanding adjournment, suggesting prosecutorial misconduct, implying witness contamination, trying to flood the room with noise before anyone could aim facts at his chest. He was shouting by the time I took the bench. I let him spend himself. Then I said, "Counsel, if you have an argument, make it. If you have theater, save it for people who paid to attend." He tried to object to the tone. That was a mistake. "Sit down," I said. He remained standing. That was a bigger mistake. I leaned forward. "Let me be perfectly clear. I am finished asking." He sat. The gallery had gone so quiet, you could hear a reporter's bracelet touch the edge of a notebook. I announced a sealed personnel matter had arisen, affecting courthouse integrity, and that appropriate steps had been taken. I did not expose more than the process required at that stage. The jury was protected. Proceedings were adjusted, record preserved, but the defense attorney knew. You could see it when his eyes moved, not to me, not to the prosecutor, but to the empty space where the bailiff should have been. Some men discover trouble, some men recognize it. He recognized it. The next days were ugly, in the way truth often becomes ugly once power realizes it is no longer steering the car. Emergency motions, requests for mistrial, claims that the court itself had become compromised beyond repair, suggestions, carefully worded, cowardly worded, that perhaps I should recuse because the leak had occurred within the judge's own sphere. That was the strategy. If they could not deny the rot, they would spread it so widely that no one could assign responsibility cleanly. I denied what the law required denied, granted what fairness required granted, and kept the case moving. The evidence from the bailiff's phone did not become a circus in my courtroom. I would not allow that. Criminal proceedings followed where they belonged. Administrative proceedings followed where they belonged. Bar discipline followed where it belonged. But piece by piece, the structure came into view. The paralegal's number led investigators where numbers tend to lead when people assume deletion is the same thing as disappearance. The defense attorney was tied to communications he should never have received. The explanations changed, then narrowed, then broke. Disbarment proceedings moved first. Criminal charges followed. And the bailiff, the man who had opened my door every morning, stood at my side and called that room to order, was led away in handcuffs because he had sold part of the court to men who mistook access for ownership. Do not tell me institutions fail all at once. They fail an inch at a time, each inch defended by somebody saying, this is not enough to matter. A phone vibration does not matter. A recommendation from City Hall does not matter. A brother's job does not matter. A few cash deposits do not matter. A motion filed too quickly does not matter. Until it all matters at once. I finished that trial. That part mattered to me, not out of pride, out of duty. Jurors had given their time. Witnesses had walked through fear to testify. The public had a right to see whether the system could still stand after discovering one of its own had tried to hollow it out from inside. So we continued. Order by order, ruling by ruling, no shortcuts, no revenge. The law does not become cleaner when a judge uses it to settle his own disgust. The verdict, when it came, did not feel loud. Real verdicts rarely do. They arrive after too much strain, too many objections, too many late nights, too many pages. People expect thunder. Most of the time, justice sounds like paper being handed to a clerk. But after it was over, after the jury was discharged, after the motions were resolved, after the appeals began their slow climb through the proper channels, I sat alone in chambers one evening and looked at the side door, that door, the one he had opened for me every morning for 6 months, the one beside which he had stood while I spoke words I believed were safe because the court itself was holding them. I had shaken that man's hand every morning for 6 months, every morning. There is no dramatic music in a moment like that, no speech waiting in the wings, just memory rearranging itself under a harsher light. A smile you now understand, a silence you now place differently. A good morning, Judge, you hear again and realize it was already carrying somebody else's business. People sometimes ask me what angers a judge most. Is it lying? Is it violence? Is it contempt? All of that has its place. But betrayal inside the machinery of justice is its own species of offense. Because a courtroom is one of the last places where a frightened person is still supposed to believe rules can beat power. If that faith is bought, leaked, or traded, then the damage reaches far beyond one defendant, or one crooked officer, or one lawyer with his hand in poison. It reaches the widow waiting for a fair hearing, the shop owner suing a thief, the young prosecutor trying a first case honestly, the juror who leaves work unpaid because the summons said truth needs citizens. It reaches every person who walks beneath that seal and hopes it means what it says. So I will tell you exactly what I learned. Never be impressed by proximity to authority. A man standing near the bench is not the bench. A uniform is not honor. Routine is not innocence. And politeness is not loyalty. Watch patterns. Respect records. Move slowly when anger begs you to move fast. And when proof finally comes, do not flinch. Because when you hesitate at the right moment, corruption hears mercy where there should be judgment. The defense attorney lost his license. He faces the criminal consequences that follow a man who chooses conspiracy over oath. The bailiff lost his badge, his freedom, and whatever remained of his name. And the court, my court, endured, not because it was untouched, but because once the rot was found, it was cut out. That is the work. Not pretending the institution is pure. Purifying it when it is not. I still remember that first morning after the arrest, a different officer stood by the side door. New face, straight posture, quiet eyes. He opened the gate and said, "Court's ready, Judge." I looked at him for a moment longer than usual. Then I nodded and took the bench. Because that is what the public never gets to stop doing, believing again. And that belief is sacred enough that if one man sells it for cash and another man buys it through a paralegal's phone, I will bring the full weight of the law down on both of them without raising my voice more than necessary. That is not anger, that is duty. And duty, when it finally lands, sounds very much like a hammer.